All right, strap yourselves in. We're going deep into a real legal drama unfolding right now, down under in Queensland, Australia.
Oh, this one's a doozy.
We're talking allegations of hacking leaked personal photos.
And potentially a seven-figure payout.
And the crazy part, it all hinges on one meeting, on what was said or wasn't.
It's a classic he said, she said, but with a digital age twist.
Exactly. Inadvertent disclosure, maybe some ethically questionable moves.
Even whispers of international cybercrime.
Enough to make anyone's head spin, so let's break it down.
Put it on me.
We've got big developer Politi Ltd, they're the plaintiff.
Okay, and on the other side?
Brisbane Engineers Politi Ltd, the defendant. Big developers suing for over $1 million, claiming professional negligence.
Big money on the line. What happened?
Big developer claims Brisbane Engineers dropped the ball. Didn't investigate the soil type at a development site.
Soil type. That sounds crucial.
They say it was a key part of the agreement, but Brisbane Engineers insists there was never any such agreement about soil testing.
Ah, so you've got a he said, she said over an oral agreement. No written contract to fall back on.
Which means the court's going to have to figure out who's more credible, whose story holds up.
Tricky territory. What evidence do we have?
Well, things get interesting. There's a leaked memo from a former secretary, Miss Forever.
A former secretary.
She was at that crucial meeting.
Mm.
And get this, she claims she was distracted and can't remember what was discussed.
Wow. Talk about a wrench in the works.
Yeah.
This sounds like what we call inadvertent disclosure in legal terms. Accidental release of confidential stuff.
Right, you'd think it's a win for Brisbane Engineers. A key witness can't back up big developers' claim.
Not so fast. There are rules about how lawyers handle these situations. Australian Solicitors Conduct Rule 31 specifically.
What does that say?
Basically, if a lawyer gets confidential material they know was sent by mistake, they can't use it. They have to return it, delete it, notify the other side.
So did Ms. Jones, the lawyer for Brisbane Engineers, know?
That's the debate. She claims she had no reason to think it was a mistake, says marking documents as privileged is common practice, even for stuff that isn't actually privileged.
So, maybe not a clear red flag.
Potentially a gray area, ethically speaking. But wait, there's more.
Oh, there's always more.
Mrs. Jones gets 2 more memos, plus a pretty scandalous photo, all from a mysterious Russian email address.
A Russian email. This is getting wild. Who are these about?
All about Mrs. Driver, the wife of big developer's director.
What do they say?
The first one, Mrs. Driver's hesitant about her husband's lawsuit, maybe thinks he's been unfaithful. But in the second memo, after they reconcile, she backs his story completely.
Whoa, witness tampering, marital drama, international hackers. This just keeps getting more complicated.
And hold on to your hats because it gets even wilder.
You're kidding.
Mr. Smith, big developer's lawyer, claims his firm's database was hacked. That's how the memos were stolen. But their IT expert couldn't find any proof.
So is it a real cyber attack or a convenient cover-up?
Excellent question. The court's going to have to figure out if those leaked memos are even admissible as evidence, and if so, how much weight they carry.
This is already fascinating, and we're just getting started. This is the deep dive, which means we're going way beyond those headlines. Our listeners know their law, so let's get into the really meaty stuff here. What are your initial thoughts?
Well, from a legal perspective, this case is a goldmine. It really forces us to examine how long-standing legal principles work in this digital age. We have rules about client confidentiality, admissibility of evidence, but then technology throws us a curveball.
And this case is a perfect example, right? Inadvertent disclosure, that's been around forever. But in the digital world, with emails flying around, shared drives, mountains of documents, it's a whole different game.
It really is. And then there's the hacking question. Can you even use information in court if it was obtained illegally? And proving a cyber attack even happened, talk about a challenge.
Yeah, the digital trail can be pretty slippery. But going back to that memo, that inadvertent disclosure, Ms. Jones, she says she got it as part of the normal document exchange. Nothing to suggest it was a mistake.
And on the surface, that seems reasonable.
Right. But I bet Mr. Smith is fuming. His paralegal slips up, and boom, potentially damaging info about his client is in the other side's hands. Can he really get that memo back just because his team messed up?
That's where waiver of privilege comes in. Did Mr. Smith or his staff basically give up that confidentiality? It's not a simple oops, do-over situation.
So even if it was an honest mistake, the fact that the memo was out there, even accidentally, could mean the privilege is gone.
That's the thing about Australian courts. They've generally held that if you voluntarily disclose privileged information, even by accident, you've waived that privilege. They focus on the action, the disclosure itself, not what you intended to do.
So Mr. Smith saying, I didn't mean to do it, might not fly.
Uphill battle, for sure. The courts tend to be pretty strict on this, but let's play devil's advocate. Say the judge tosses the memo. We still have those Russian emails looming. Can they be used against big developer, even if they were, well, ill-gotten?
Now that's venturing into ethically murky territory. You can't just hack into someone's database and expect to use that info in court, right?
You'd think so. There's a legal principle, fruit of the poisonous tree, basically says evidence from illegal means is a no-go.
But didn't you say Australian courts have some wiggle room?
They do. There are exceptions. If they decide it's in the interests of justice, they can admit illegally obtained evidence.
So, hypothetically, if those emails have some bombshell revelation that clears Brisbane engineers, the judge might allow them, even if they came from hackers.
Possibly. It's a judgment call. They'd weigh how bad the illegal act was against how relevant and important that evidence is to the case.
A lot to consider. So, even if those emails never officially become evidence, could their existence still sway the judge? Like, maybe plant a seed of doubt about big developer side of the story.
Oh, absolutely. Even if they're not presented directly, they can cast a shadow. The judge might be more skeptical of big developer knowing this potentially damaging information is out there.
Okay, let's shift gears a bit. The core of big developers' case, that oral agreement about soil testing, how can they possibly prove something like that happened, especially with the secretary saying she can't remember the details?
This is where it becomes a battle of who's more believable. Mr. Driver, big developer's director, he'll definitely testify that he did discuss soil testing with Mr. Figures from Brisbane Engineers. And Mrs. Driver, despite her initial hesitation, she might back him up now.
But it's still their word against Mr. Figures, isn't it?
Yeah.
And this forever's fuzzy memory, that doesn't help big developer.
It does weaken their claim. She's an independent witness, no obvious reason to lie. So, yeah, it could come down to a he said between Mr. Driver and Mr. Figures.
So then it's all about persuading the judge who's more trustworthy. This is where the lawyer's skills really shine, right?
Absolutely. Get ready for the courtroom tactics. Pointing out inconsistencies, hinting at biases, painting their client as the honest one.
So rapid-fire questioning, dramatic pauses, objections galore.
Oh, it can get theatrical, especially with this much money at stake. But beyond the theatrics, some crucial legal principles come into play. Burden of proof, for one.
Remind me, what's burden proof mean here?
In civil cases like this, the plaintiff, big developer, has to convince the judge that it's more likely than not that Brisbane Engineers messed up, that they breached the agreement.
So even if the judge isn't totally buying Brisbane Engineers' defense, they could still rule against big developer if the plaintiff hasn't proven their case strongly enough.
Exactly. Burden of proof, it's fundamental. The plaintiff has to bring the evidence, not just rely on the defendant to disprove their claims.
This is making me realize how nuanced these legal proceedings are. It's not just about who's right or wrong in some black and white way.
You got it. It's this web of rules, precedents, strategies. And in this case, throw in alleged hacking, questionable evidence, ethical dilemmas. It gets really tangled.
So as we watch this trial play out, what should we be looking for? What could sway the judge?
Well, first, that ruling on the leaked information. If the judge allows those Russian emails and the photo, that could really hurt big developer.
What about the witnesses? Anything to watch for there?
Definitely pay attention to how consistent the drivers are. Do their stories match up, detailed and believable? Any contradictions could raise red flags about their credibility.
And on the other side, how will Mr. Figures do under pressure?
His testimony is key for Brisbane Engineers. He has to convince the judge there was no soil testing agreement, that his firm did everything right.
Sounds like a real courtroom showdown brewing.
Yeah.
So much depends on the judge's interpretation of the law, the evidence, legal arguments.
You said it. Even in law, where things seem objective, human judgment is always a factor.
Our listeners, they're sharp legal minds. Any specific arguments or precedents you think might pop up? Where will the lawyers focus their energy?
I'd be watching that implied waiver of privilege angle closely.
Mm-hmm.
Lots of case law in Australia on that. Both sides will probably pull out those precedents to support their arguments.
It seems like there's plenty of ammunition for both sides to use. And speaking of precedents, what about cases involving illegally obtained evidence? Has Australia set a clear standard for when that kind of evidence can be used?
There have been some big cases here in Australia that have tackled that tricky issue. The courts know there's a public interest in upholding the law, and that means discouraging illegal activities even when gathering evidence.
So they have to balance that with ensuring a fair trial where all the relevant evidence is considered.
Precisely. It's a delicate balancing act, and ultimately, every case is judged on its specific details. How serious was the illegal act? How reliable is the evidence? Could it unfairly harm one side? Those are all factors the court will consider.
So let's talk outcomes. What are the possible scenarios here?
If big developer convinces the judge that there really was a spoken agreement and Brisbane engineers broke it, they could win big, over $1 million in damages. Those damages would be to cover the financial losses from the alleged negligence.
That's a massive win for big developer if they can make it happen. But what if the judge isn't buying their argument? What then?
If the court rules in favor of Brisbane engineers and dismisses the case, big developer will likely end up paying at least part of the defendant's legal fees. That could add a serious financial sting to their existing losses.
So both sides are looking at potential financial hits. But this feels bigger than just dollars and cents, doesn't it?
It does. This whole case could seriously damage the reputation of both companies. If Brisbane Engineers is found liable for professional negligence, clients might hesitate to hire them. Nobody wants to work with a company that's potentially careless or incompetent.
And for big developers, even if they win, the fact that this whole thing went to court, the leaked emails and everything, it could make people question their judgment and business practices.
Right. This could have consequences that reach far beyond the courtroom, affecting how the public views both companies.
This has been a real eye-opener, this deep dive into the intricacies of litigation. We've got alleged hacking, ethical dilemmas, and enough legal twists to give anyone whiplash. But taking a step back, are there broader takeaways for the legal profession?
Absolutely. This case really emphasizes how vital cybersecurity is in the legal field. Law firms handle incredibly sensitive information, and a data breach can be catastrophic.
Like you said before, the legal world's changing fast, and lawyers need to keep up. It's not enough to just know the law anymore. Understanding technology, how it interacts with legal principles, that's crucial.
Couldn't agree more. This case also highlights the importance of clear communication and careful record keeping. Imagine if that alleged agreement about the soil testing had been put in writing. We might have avoided this whole situation.
That's a classic lesson. But it's easy to forget in our busy world. Having a clear, written contract can save everyone a lot of trouble and potentially expensive legal battles.
And let's not forget the ethical aspects. That accidentally disclosed memo brings up questions about handling documents properly and the lawyer's duty to keep client information confidential.
It reminds us that ethics should always be front and center in legal practice. Sometimes doing the right thing means passing on a possible advantage in the case.
Well said. This case really shows how technology, ethics, and human actions all come together in the legal world.
This has been a fascinating deep dive, and I'm sure our listeners have gleaned a lot from this detailed analysis. It's a case full of intrigue and uncertainty, a stark reminder that even seemingly simple disputes can turn incredibly complex.
I'll be watching closely as this case progresses. So many questions remain unanswered, and the outcome could have a major impact on how law is practiced in our increasingly digital world.
We'll have to see how the judge rules on those key issues, whether the leaked information can be used, how believable the witnesses are, and ultimately, if there was ever a valid agreement in the first place. Until then, keep those legal minds sharp, and remember, the law might be blind, but it's not deaf to the whispers of the digital age.